stove should be preserved for examination since that's the key item about how the fire started.
Stove should be preserved.
And we'd like
Is the cat going to testify? I'm sorry. I thought I'd ask.
Hear me, yo. Watching how them opera boys get sentenced. You know how the fuck's going on, man. Y'all boys tuned into that Oouchie Court Watch. Well, we taking it straight from the jail cell to the judge. Hear me?
Court does call the case Marshall Real Estate Group versus Gary Ziegler.
Hey, good afternoon. Ryan Sweeney appearing on behalf of Marshall Real Estate.
All right. And Gary Ziegler, are you here? Oh, he's up there. Mr. Ziegler?
I see him, and last week he had to call in or do something different. I don't remember what it was.
Yeah, I see him on my screen, but there's no response coming. Mr. Ziegler? I think we had to do this last time. Yeah, he muted. Mr. Ziegler? You can probably hear me. We can't hear you because you're muting and unmuting. I'm going to suggest that you sign off and sign back in, and then we'll call it back up, Mr. Sweeney. So I'll call it right when we see him again.
Thank you.
All right, quarter past that matter.
Yes, sir.
The individual who has signed in or dialed in one with the last three digits of 173, if you could please hit *6 on your phone and unmute and identify yourself.
Hello?
Hello? Who are?
Judge, my name is Gary Ziegler.
Okay. So first thing, Mr. Ziegler, whatever other, oh, he's just gone. Where? Oh, no. He's there.
Judge?
Mr. Ziegler, you there?
Yes, sir.
All right.
I apologize. Obviously my computer is not Zoom friendly.
Yeah, you're
Hello?
probably right. It's by no means, I'm sure, a user error. Stay right there.
I apologize for that.
No, it's okay. Let me call that case counsel and just Marshall Real Estate Group versus Gary Ziegler.
Ryan Sweeney appearing on behalf of plaintiff Marshall Real Estate Group.
All right.
Gary Ziegler here from Saline via phone.
Okay. And where are we on this case, folks?
So last time we appeared, Your Honor, Mr. Ziegler was set up with a social worker to assist in getting his application in this court, ordered that it be filed with or provided to the court proof of the application being submitted by Wednesday of this week.
Yes. And I don't have that. I don't think. Hang on. No, I don't have anything.
I have a copy of it right here.
When did you send it to the court?
Monday afternoon, 4:00. So we're talking the 27th. It was supposed to be there by 4 p.m. on the 28th. It's the
right.
Sears,
And
it's
okay, that might be an error on our part, and it just didn't get to my file. Your social worker was helping you get that in, right?
correct.
Okay. So you're entitled to another adjournment because of that. I'm going to assume that he got it in, Mr. Sweeney.
Okay.
And what have you applied for? You applied for an SER, and then did you contact Hawk?
Yes.
Okay.
Nothing.
Did they give you an appointment?
I've talked to people on the phone. I haven't been out. I'm partially disabled with side effect neuropathy, plus my car is currently inoperable, and I don't have the funds to fix it. However, Amy, the court liaison that I've been working with since last meeting, has given me 4.5 pages of resources to work. I'm about 60% done with them, but Judge, one of the resources gave me an additional 223 resources. I kid you not. I wouldn't waste the court's time on this. Okay? So I have additional resources to work through, but I'm just going to be perfectly candid, save everybody some time. Here's what
Probably
I'd
too
like
late,
to do.
but go ahead.
Okay. Point taken.
Go ahead, Mr.
Yeah, I know I need to give this, and I haven't talked to an attorney. Nobody's even answered the phone, all due respect. Swear to God. Okay. But I want to end this, okay? And I know that I need to end this by paying what I'm due, but I want to try to work in the next 2 weeks to move out of here and at the very least give the Marshalls their apartment back.
Okay.
So in a nutshell, I know that, I know that's all fine and dandy, but no ticky, no laundry, bud. Right. You owe $3,750. If there's one of the resources that I just found was the dispute center. Obviously, I don't want an eviction on my record, but I'm headed there for sure, unless I, either cough up the money or move. I'd like, if I can be so bold, is to please ask for another 2 weeks work effort to meet that end, to at least move out of this apartment in 2 weeks and give the Marshalls back their apartment.
So Your Honor, what I'm hearing almost sounds like a consent for possession in 2 weeks. If the funds are not paid by that date, he will move voluntarily. And I would do that as like a pocket judgment so that no eviction would go on his record if he does actually keep to his word and either pay or voluntarily move.
Well, it won't be for lack of effort. That's all I can promise. Like
Okay,
I said,
so-
I don't even have, it will not be for lack of effort. Go ahead, I'm sorry.
It's all right. Here's what I'll do. And I'll take that into consideration if he doesn't move out in terms of the time limit, Mr. Sweeney, that will be granted on any judgment. But I'm not going to grant a judgment that way. But what I will do is I'll adjourn this out 2 weeks, let him see whether or not either he's going to come up with the resources to get it paid or vacate the premises at that point.
Yeah.
Okay.
Let me, Your Honor, if I could, one last thing. I have a tentative acceptance in 2 senior housing units, McNamara Towers in Livonia, and Dunn Family Co-op Apartments in Centerline. I've submitted the paperwork. I'm not only in line, I've been told by parties verbally, okay, in all honesty and candor, nothing in writing. They won't give you, for whatever reason, they won't give you even a tentative move-in date. But I am on the waiting list, and I am very high on the list. And in all honesty and candor, both of those places, okay, again, McNamara Towers in Livonia and Dunn Family Co-op in Centerline, which I would gladly take. Beggars can't be choosers. I'm in a tough spot. I need to go. I get that. Okay, so I have the deposit for both of those places, and I have a tentative agreement from my brother to cover the moving costs.
Okay, I get that. So here's the thing, Mr. Ziegler, you need to make a decision on which way you're going. I'm giving you 2 weeks to do that. Okay?
Understood.
All right, February 14th, 2025 at 1 p.m.
Thank you, Your Honor.
Oh, you'll send a note. Yeah, okay. Okay, you'll send a notice for that, right?
I'm presuming we will, yes.
Yeah. All right.
Thank
Thank you, sir.
Thank you.
I can hang up, right?
Yep, you can hang up.
Okay, thank you. Thank you.
Bye.
Bye.
Court calls the case of Arbor Manor versus Mika Claiborne.
Thank you, Your Honor. Paul Hughes, P 31986, appearing on behalf of the plaintiff.
Hi, how you doing?
Hello, what's your,
Hi, Judge. Doing well.
pardon?
I'm sorry?
Your name?
Mika Claiborne.
I knew it. I just wanted to hear you say it. All right. Okay, where are we on this case?
Your Honor,
Okay, so,
we have two cases that were before you today for a fourth hearing. You were working with the defendants and allowing for assistance to be processed. The other case will be dismissed. Ms. Claiborne's case, they have not made the commitment for payment. And I think she was getting payment from Hawk. The balance that's due is $2,363 plus court costs. And I'm not sure what the status is. They haven't received written commitment from them.
So you haven't, on the other case, you've received the commitment, and that's why
Yes, sir.
you're dismissing, but on this one, you haven't received the commitment.
That is correct.
may I speak, Your Honor? So, is
Can I
that okay?
stop you?
Okay.
Go ahead.
So,
Go ahead.
I just got off the phone with Alicia Sykes, who is my caseworker for
Right.
SOS, and she checked and she said it's not yet approved, but most likely will be at some point in time today. She just needed like the last couple documents from me last night, and I sent them to her. So it's like processing in the system, and so she said it will be for $2,363.
2006.
363.
2006.
Yeah, and then I also discussed with her that I will be making my February payment on the 5th, because I get paid the 5th and the 20th of every month.
Gotcha.
By
Okay,
month.
so you're gonna make your February payment on the 5th.
Yes,
And this, give me that number again, just say
$2,363.
363. And that, the 2363, Mr. Hughes, that will cover the balance?
Of the rent through January, but not the court cost of 162, and February's rent will be due tomorrow.
Okay, so, right, so that's what I was trying to get at. So what our problem's gonna be this, not a huge problem.
Okay,
There's gonna be you pay your February rent,
okay,
but what they're paying, that's correct, is going to not include the court costs.
okay,
So
so,
you're gonna end up with 162 short.
okay,
So let me ask you this. When you get the pay on the 5th, can you pay February plus the 162? Is that a possibility for you? I know.
only because
The rental amount looks like it's 50.
it'll be 235.
Hold on. I'm sorry, Mr. Hughes.
The rental amount looks like it is $59.
No, they just raised it to 73. I actually just signed a document.
Oh, okay. So
I went in office,
73.
So it'll be 73 starting February plus the 162, so 235.
Yeah.
I can I split it in half between the 5th and the 20th of February?
Okay, let's do this then. Okay, because it's so close that we don't have the commitment, but you're saying they told you that it would likely be committed.
Yes.
All right. So what's half of 6281? So
when I pay the court costs, would that be paid to Arbor Manor or to you guys?
oh no, it's payable to them.
Okay.
Okay.
So
So here's what we'll do. What I want you to do, and I'm going to do one last adjournment, because if it's approved today, they then should get the commitment.
Mhm.
I want you to pay 154
Okay.
by
On 5th.
February 5th
Okay.
to the landlord. All right.
Or-
What that is that's half the cost.
Okay.
And then what's going to happen is somehow or another, we're going to still have a balance of 81.
Okay. And I could pay that on the 20th February.
Right. The problem is I don't want this case to run out that way.
Right.
Okay. So we'll figure something out. If you happen to think you can squeeze that 81 out so this thing can be done with and get dismissed, I'm going to suggest you do that.
Yeah, I'm gonna
Okay.
try for sure.
Because that will be the better way to go.
Yeah,
If we can do that.
that sounds good to me. I'll definitely do my best.
54 by the 5th. And I will adjourn this out one last time so we can get that commitment in to February 14th, my next date, February 14th, 2025 at 1 p.m. So the whole key here is if you can get that 81, the 152 plus that, or 154 plus the 81 in,
Mhm.
then what will happen is on the 14th, it goes away.
Okay.
Okay.
Well, if I pay it before the 14th, will I still have to show up to court? Yes.
Pay the 81, you mean? So you pay the 154 on the 5th and then find the 81 between then and then we're good then too.
Would I still have to show up to court though on the 14th?
Why, you don't want to come see me?
I mean, I'm just asking.
This is how my feelings get hurt.
I know I want to see you, but you know.
Okay. No, you wouldn't have to as long as the landlord is clear that you paid it.
Okay.
So you have to make sure that it's paid enough in advance of the 14th.
Okay.
Okay?
All right. That
Okay.
sounds good. Is there a number for me to contact court if I just want to like double check? I mean, double make sure.
You can call, Mr. Hughes, for you would suggest she call the apartment complex?
Yes, and if
Or
you
you.
can't get a hold of them, my phone
just
number
ask
is
them-
on the papers.
Okay, so
Okay.
call the apartment complex. If you can't get through to anybody, then call Mr. Hughes' office and that's on your paperwork.
Okay.
Okay?
Got it. All right.
right.
Sounds good to me.
Okay, take care. We may or may not see you.
Alrighty, hope
All
so.
right. All right, take care. Sycamore Meadows versus Caleb P.
Again, Carrie Zim,
Jill Bauer on behalf of Ms. Case is also present.
All right.
I know that last time I wasn't here, there was, I got an email from opposing counsel regarding a stipulated order. I sent her a revised stipulated order as to what my client would be willing to agree to, meaning to give Ms. P sometime a date where she can get everything out of the unit. And she can take anybody that she needs to take with. We're just asking that they wear appropriate face coverings because of the situation. I wasn't here. I heard through the grapevine of what happened. I just want the court to be aware it's not about, it's about insurance bids. I mean, realistically, insurance bids and contractor bids and making sure that we have the appropriate people in the unit. All of the things need to be removed, Judge. It's soot filled. There's a wall that needs to come down. Am I correct? There's a whole wall that actually needs to be replaced. So it's not something where council wanted Ms. P to be able to leave items upstairs. That's a problem because the smell is going to stay. You know all of the things I'm going to say to you. And so I really just need all of her stuff out and then they can do what they can do. And that's where I'm at. That's what I can agree to at this time. And I sent that order over to opposing counsel for review and they can pick a day.
Well, Your Honor, if they're willing to rehouse her, she would have a place to remove her belongings too. But she's living in her car right now.
Judge, I don't think that's quite accurate because my client's actually seen her with her grandma, who's also in Sycamore Meadows. So I could be wrong, but I believe that that's where they've seen her living and residing. At this time, Judge, I don't have the authorization to agree to rehouse her, and I don't think that my client's willing to do that either from what I've been told at this point. So I'm willing to give her the time that she needs to get her stuff out of there so they can get in the unit and do what they need to do.
And we believe that they should be rehousing her. So we'd ask the court
But
to,
she's not in the unit. So I guess I'm unclear as to why you're holding the unit hostage.
well, we're not really
To put it
holding,
bluntly. I mean, because that's what you're doing. I mean, they can't, if her things are in there, they can't do anything. And so I don't know who that benefits.
well, Your Honor, I was not aware that it seemed to me that the damage was just in the kitchen and that there wouldn't be any work being done upstairs. So that's why I thought she could leave her large items upstairs because she has nowhere else to put them right now. If she was rehoused, she would have a place to put them. That's what I was thinking. I did not have the information that a wall needed to be replaced. That would make it untenable to store things on the second floor.
Okay. So now we are aware that that's the case. So what's defendant's position now? Because whether she's rehoused or not, you can't just hold this unit. I mean, I can issue an order that she has to remove her items, or she's at a certain date they're abandoned, and then they can remove them.
Well, I just heard with you that the second floor, so can I ask her if she has a place to move the larger items? Your Honor, Ms. P has items in the unit that she wants to remove, but she's willing to not take the larger items because she has nowhere to store them, but she just wants the court to be clear that she's not surrendering her right to the unit. She's just removing her things so that repairs can begin. That's what she's concerned about.
At this point, I think I've said it already twice now. My client's not willing to rehouse her. I don't, at this point, I just need her to get the stuff out so that we can get done what we need to get done. This isn't the first fire that took place in this unit. This is the second fire, so there's problems there, but I think before the court today is what we've discussed about removing the items, and so that's where I'm at.
The order that was sent over regarding removal, what was the date?
I just need her to pick a date. And so that the order says that within the next week, she'll pick a date and she'll be able to go on that date and bring individuals with her. Can I see the?
That's my order.
Oh, okay, Judge, I sent it to her. I thought she.
Okay.
It was one paragraph, Judge, and I'll read it to you. Defendant shall be provided a full day within the next week to go through her belongings and remove any and all belongings from the unit. Defendant shall be allowed to bring people with her to assist her. Defendant and anyone going into the unit shall wear protective clothing and mask while in the unit. So ordered. And if she wants to pick a date now, I can revise it and put the date and the time she'll be able to be there.
Give me a date.
She needs to talk to find out who can help her, but she will pick a date.
Okay.
7th of February, so within the next week.
Okay, so here's what I'm gonna do. I'm not this way. Can't pick a date, I'll pick a date.
Okay.
It was February 6th.
Thank you, Judge.
Thank you, Judge.
So put that in the order. I'll
Yep.
sign the order. And then what do I need to do? Adjourn this case out to deal with the.
I have two other things that I want to put on.
Sure.
I'd like to add an explicit sentence to the order that clarifies that she's not giving up her right to be housed by emptying out the unit.
Well, if the case continues, of course she's not. She's
Okay.
challenged. I don't know why that needs. to
Okay,
be
I
there,
just
but
want that to be part of.
Otherwise, she'd get her stuff out and we're done, but obviously we're not.
Okay.
I'll be
The other.
handling this when I get Social Security, apparently. Go ahead.
Okay. I think that the stove should be preserved for examination since that's the key item about how the fire started.
The stove should be preserved.
And we'd like.
Is the cat gonna testify? I'm sorry. I thought I'd ask.
Your Judge, there's pictures of the stove and with the, I think they're attached to, there's actually pictures and in the fire report with showing that the stove was actually on, that the knob was on to turn. So I don't know what.
Yeah, I know, but the issue is whether or not a human being turned it on.
I don't know what the issue is, Judge. I understand very, very clear my
I'm
issue.
not sure how we're gonna resolve that, but
I'm not either,
I'd
but
like an opportunity to see if I can find someone who might be able to weigh in on that.
I don't know how
is
this,
cat still available? I mean, I just asked you a question because. Do you still have the cat? Okay.
Judge, I don't know how she wants me to preserve the stove. I have no way of preserving the stove. So unless Miss,
Well, I would imagine that Sycamore Meadows has some storage. I mean, I get the request because somebody's gonna have to show me how this.
there's actually a statement in the report from the fire chief that Miss P said that when she walked in and saw the smoke, she heard the clicking of the stove and then walked back out as well. So I don't know how preserving the stove is going to change any of the evidence that's out there, but.
Are you want the stove preserved for what purpose? To determine whether or not
It
there's
could
some.
be started by an animal. I mean, that's what they put in their motion that I got yesterday.
But
Is
that's
that-
what was I didn't put that in the.
But that was a statement, I think, by your client
But-
to the fire.
But she recorded the conversation with the fire department. That is not what she said. So the fire report is not accurate.
Okay, well, to make it fair, you guys are gonna have to find some place to store the stove. The stove, prepare an order, gotta preserve the stove as well
If my
as.
client has no place to put it, what would you like me to do? Does Miss Bauer want to find somewhere to preserve it? Judge, because my client doesn't have storage. If they, I mean,
Can you guys work out where to store it? I mean, because obviously somebody's gonna have to pay to have it, or
why doesn't she?
what do you want to do to this stove? You want somebody to go and tell you whether or not this stove can be turned on by an animal, right?
I'm sorry, Your
So-
Honor. Could you repeat that?
I know, Miss Lee was all in your ear. So when would you get the person out?
I'll start working on it immediately. Maybe the stove could be moved to the basement since there's not going to be any work done in the basement.
Well, I don't know that. I mean, I'm not the contractor, so I don't know whether or not it's,
I mean, if,
okay, so I'm gonna be serious about this for a moment. The stove needs to be put in some secure location. All right, you're just gonna have to, plaintiff is gonna have to figure that out.
That's fine, Judge. I'll figure it out.
Okay.
And then the last thing, Your Honor, is, I finally got, paperwork for the case this week. I'd like to file an answer on behalf of Ms. E. I need time to file an answer to the motion that I got yesterday, and then possibly draft my own motion for summary disposition. So I need time for those things with permission of the court.
How much time are you gonna need?
I would like 3 weeks. I don't know if the court would give me 3 weeks or not, because I still have a FOIA request that I'm going to be picking up today that seems to be pretty lengthy.
Judge, we're before you on the 18th of February. You can stick us on that date. You're okay with that?
Probably not, but
Okay.
I mean, I will. But here's what I'm gonna do. I'm not giving you 3 weeks. You need to file it by the 14th.
Okay. Thank you, Your Honor.
And then I will adjourn this matter out. We can put you on the 18th.
Okay. Thank
And
you.
then we'll figure out where we're going. February 18th, 2024, 9 a.m. That's
Thank
in
you.
person. You prepare the order regarding preservation, and you prepare the other order, and then I'll sign it. Thank you. I do also want a picture of the cat's front paws.
Can I just make sure that the things on top of the stove don't need to be preserved? You just want the stove put in a location in the basement or something
Yes,
like that?
that's-
I can get rid of all of this, correct? Because I'm not gonna be able, the
Yeah.
problem with preserving everything that's burnt on the stove is the same problem with all of the stuff.
I don't
in-
think we have pictures of that. I think we're just interested in the mechanics of the stove being able to be examined. So that's fine.
Okay, thank you,
Okay.
Judge.
And I want pictures of the cat's front paws extended as well as the rear paws, not that those are as important for me.
Okay.
Thank you. Court calls the case, the people are Jared Lepick versus Andrew Elliott.
Hello, Your Honor. I'm Jordan Lepick. I'm also on this case. Jared Lepick
Yes.
unfortunately was diagnosed with influenza A this morning, so he has his Zoom going and can mic in if need be, but he's got very little of a voice left at this point.
Okay, all right. And yes, I do see him signed in. All right. Andrew Elliott or Travicia, is it Burrell?
Traversa Borelli.
Okay, sorry.
That's
All
all
right. Okay, what are we doing on this case?
Last week, sir, you had asked that they be out of the house before the hearing today. And as of right now, they're still moving stuff out of the property. There are still people on property, including a couple of unauthorized additional roommates that weren't included in the lease. And we have yet to get in contact with Mr. Elliott. He is the named person on our lease. So we would just like to see what his status is. We haven't heard from him since the 7th. And the last thing we received from him in writing was an email admitting to the debt owed and the wrongdoing on his part, stating that he can provide the court of a copy with this email. In his own words, he states, "We will obviously not refute what you are owed. We have no intention to. We would honor the court decision of the debt, which would additionally include legal fees. Given our contract is under the laws of Michigan, there is very little that can be garnished as the bulk of my earnings are earned as independent contractor." In this email, he proposed a payment plan that we were uncomfortable with agreeing to because he offered us specific payment arrangements over the last.
Can I stop you, please?
Absolutely.
All right. How much are you claiming is owed?
So as of right now, he owes $15,000 plus court costs of $234.43. If I may, could I give you like 90 seconds of backstory, sir?
Not really.
Okay.
Your Honor,
I
if
don't
may.
know that I'm necessarily gonna need it.
Okay.
Ma'am, are you moving out?
Yes, we've returned the key. I have a couple of friends currently helping me move out the remaining things. I'm actually at the U-Haul Center right now, and they are getting the rest of the items out presently under the supervision of the land manager.
Okay. So, and ma'am, are you disputing the amount they're claiming is owed?
I am.
You are?
Yes, I am. We
Okay.
owe.
How much do you think you owe?
So we owe December and January. That's 10,000. We paid a $1,000 late fee in November and a $2,000 late fee in September and October. We believe that these should be subtracted from the total owed due to illegality of those fees. Also, we were subjected.
How much is monthly rent?
Your Honor, monthly
5,000.
rent is $5,000 a month. This is a 4,000 square foot house that we were under contract for them to purchase. And we have done a series of short-term leases as they were waiting on the state.
Okay. So here's the thing. Is she right about, she just listed off, I think, $4,000 of late fees that they paid.
No, sir, that is incorrect. Those were from the previous lease. See, at first we did a 60-day lease, and then we extended that once their house was not sold. So we have 2 prior leases to this short-term lease, and we only enforce late fees on one of the months under those leases. And I can submit documentation of all this, sir.
So can I.
All right.
I do have claims that ACHs were sent that were never received to my account, sir, as well as proof of funds that I received in December and no payment was made out of that. The last communication I had about a payment arrangement was on December 13th, and I was informed by Mr. Elliott that day that his wife had sent an ACH. However,
Okay, look, folks. Oh, ma'am.
Yes.
Here's what's going to happen. What date are you going to be out of the premises?
We're already out.
Your stuff
You're
is still
already out.
Right.
Your stuff-
And they have surrendered the keys?
Yes, and it's in the process of being removed as we speak. So we are out. It'll be another hour or 2, I think, before it's all of our stuff is gone.
So then the only issue is what's owed.
Right. I also want to bring up, if I may, Your Honor, we were subjected to a wrongful lockout, so we are due 3 times damages of the $150 for a locksmith as outlined in Michigan's anti-lockout statute, totaling $450, which I also have evidence of.
Okay. All right,
Your
look,
Honor.
folks.
Your Honor, I'm
Yes.
in a rent house because they failed to pay rent. I have 6 children. These people make $350,000 a year is what they claimed on the rental application. I'm going to lose health insurance tomorrow, and my house is going into a foreclosure period as of tomorrow is 90 days late. They have money. They had subletters or whoever living with them, and I don't know if they were running a homeless shelter, if they were pocketing the rent that their roommates paid. They've
No.
just been sitting in my house, sir.
This is incorrect.
Okay. All right. So here's the thing. Possession has been granted. There are 2 parts to the case. Possession's been granted or surrendered to the plaintiff. So possession is not.
Sorry.
Pardon?
There are still people at the house. One of them had a residence established there, apparently. They're still at the house, and unfortunately, our property manager expired at noon today, as it is the last day of the month. So any clean out of anything left behind, I'm going to have to go assess for any damages left on my own next week.
All right. Okay. So here's what I'm going to do. They've surrendered possession of the unit. Ma'am, to your knowledge, are there people in the premises?
Yes, there
Ms.
is.
Burrell, are there people still in the premises?
I don't know. I would have to text them. I don't know if they're on the premises presently, but we were told that we could get the remainder of the items out. So they would be doing that if they are not presently at the U-Haul Center where I am now. I'm just
So
using
here's
my
what I'm
phone
gonna
to do
do.
this.
Possession to the premises has been surrendered. Ma'am, as of given everything that I'm hearing, your management contract expires what, at midnight tonight? Is that the deal, or?
Yeah, yes. And we can't afford to pay
All
a
right.
property manager anymore.
Hang on. I hear you. I'm just trying to, because you're in North Carolina, right?
Yes, sir. But I will have to make a
Okay.
trip up to North Carolina to assess anything.
I know. I'm just, I guess you're out of state. You've got a property manager here that won't be the property manager tomorrow.
Yes, sir.
So what? I should let you guys talk and then I'll just go back and then come back out. Because either you're going to listen to me or not. Possession's been surrendered. I'm going to give the authority, I'm going to grant to the plaintiff the authority to prevent waste under 4.201I, that you may lock and secure the premises effective 3:00 today. The reason I'm doing that is so that you can get your property manager, go over there. You can order a locksmith. You can change the locks at 3 p.m. today. Whatever else needs to get out, if you don't get it out by that time, you said you surrendered, you're giving them the keys, they giving you grace to get some of the stuff out. If it's not out, not out.
That's
But the
perfectly fine, Your
premises
Honor.
will be locked.
Thank you.
Then the issue regarding the money is going to have to be done. Now, I might as well, because the parties don't seem to agree, set this matter for trial. You have to come up next week. Is that correct, ma'am?
Yes, sir.
Okay, so trying to time this, if you come up, how long are you going to be up here?
Very short amount of time, sir, as I have children in North Carolina in school. So a day.
Okay.
Enough.
So if I I was just going to set this for a trial. So I can set a trial date, but I'm going to need the parties in person because apparently there's going to be a lot of documentation. So I'm trying to set it. So here's what I'll do. Because we're really talking about the money, but we got to get the premises secured first. So we've dealt with that. What's my date? March the 4th? The 11th. All right. So what I'm going to do is I'm going to set a non-jury trial as to the money issues for March 11th, 2025 at 9 a.m. That's in person. So I've tried to set that, ma'am, I tried to set it out far enough so that you could make arrangements or do what needs to be done to come up. We'll hear it that day. So if it has to be a one-day trip, it's a one-day trip. But I've just tried to put it out to, well, I think you get what I'm saying. Okay?
Absolutely.
But I'm allowing you to secure the premises. You're going to come up here, check on it. That way you can assess what damages or other things there may be there. Bring ledgers, all other documentation you want the court to look at on March 11th, and then we'll hear your case. Okay?
Your Honor, might I ask one question?
Sure.
Rather than pushing it out, I can make arrangements. I will make it work. Like I said, we're actually going into a 90-day foreclosure period tomorrow. And so time is kind of of essence.
Got it. Then the best I could do is the 18th. What day? Yeah. The best I could then do is February 18th. I could push it up to that day. Will that be better for you?
Yes, sir. Thank you so much.
So non-jury trial in this matter then will be set for February 18th. 2025, 9 a.m. Okay.
And one more question. Will Mr. Lepick have to appear as well, or will me be appearing sufficient just because he can't afford time off of work right now?
Well, he might want to have himself, if you're here, he may want to have himself. I will allow understanding childcare work, those things. I would allow him to appear via Zoom.
Thank you. And as far as
so
Mr.
that
Elliott,
he's present,
Okay.
but you will have to be here in person.
Understood. And Mr. Elliott?
He needs to appear. If he doesn't appear, then I do what I got to do.
Okay. Thank you, sir.
Your Honor,
Thank you.
may I ask a question?
Sure.
My partner might not be able to get off work either, but I can show up. Is that a problem?
I will give you the same. Okay. I will give you the same opportunities that I give the other side in fairness. So you may appear, but he would have to be available via Zoom.
Okay. Thank you so much.
Thank you.
Thank you.
Michael Scott Stone versus Kevin Smith.
Yes, Your Honor.
State your names.
Michael
Kevin
Scott
J.
Stone.
Smith, sir.
Where are we on this?
He has failed to pay me any rent or for the utilities since June of last year and refuses to pay. And I wish you to order a 10-day where he'll be removed by the sheriff within 10 days.
And did you send a copy of this information to him?
Yes, sir, I did. He received it yesterday at 2:33 p.m.
You have the documents?
Yes, text messages and yeah, it's nothing, Your Honor. He's just
So
trying
I'm gonna have to
confuse
set
you.
this for trial. I do my trials in person. You're down in Florida. He's here. When I read through them, they're at least what potentially could be colorable defenses. I don't know until I hear the testimony.
Your Honor, I'm a working man. I make $24 an hour and I'm paying his rent and utilities. I'm living off credit cards.
Sir, you know, every time you come here, you try to tell me how this is going to be.
No.
You have property here in Michigan. You may be down in Florida. You may be a working man. I consider myself that too. This happens to be my job. My part of my job is setting a date for these trials to get them resolved. Now, if what you want to do week after week is sit here and try to lecture me on what Michigan law should do, then I'll just keep setting it every week. He'll come back. You'll just try to give me that lecture and we'll just move on. I'm trying to resolve the case. So I'm going to set a trial date.
So today's not the trial date?
No.
Okay.
I'm going to set a trial date. Maybe you didn't appreciate what I said. That
Yes.
trial date will be in person.
Well,
If you had listened to the case before, I realize there are people out of state. I will try to accommodate that the best I can. So I'm going to set a trial date in person. I can set it for February 18th or March 11th.
Your Honor,
Your preference?
Can I have an attorney represent me there?
February 18th, sir. The reason being is because
I don't care.
Yes,
I
sir.
didn't ask that. Can you be here February 18th, sir, for a trial?
Can I hire an attorney to represent me there?
Pardon?
Can I have an attorney be there present for me?
Absolutely. You can have an attorney here.
Okay.
That might be wise because then I don't get lectured.
Yes, Your Honor. So,
Non-jury trial in this matter
Your Honor.
will be set February 18th,
Yes, Your Honor.
2025, 9 a.m. in person. I will allow testimony over Zoom, but there needs to be a party here. Yes, sir.
Is on what basis is any of this evidence going to allow him to continue to stay there free? I don't understand.
Pardon?
There's nothing in any of this that it gives him the right to continue to stay there for free. I don't understand.
Then get an attorney, and then maybe then you'll have some clarification if you listen to him.
Okay. I don't understand his claim of how he can continue to stay there for free. There's nothing in those paperwork.
Okay, just because you rephrase the question doesn't change my answer.
Okay. All right, so I will have an
Sir,
attorney.
you had a question?
Not a question, Your Honor, a statement that I would like to make, please.
Oh. About what?
Mr. Stone and the status of the condominium, sir.
And the status of the condominium
Yes, sir.
in terms of, go ahead. It's got to be brief, and I may cut you off.
Yes, sir. Very brief, very short. Mr. Stone has known since, I'm sorry, Your Honor. Mr. Stone has known since 2022 that he should have the place registered as a rental property. Mr. Stone received.
That is a defense, and that you will raise at a trial.
Yes, sir.
I've set a trial date, and God help me, I'll be here to hear all of it.
Yes, sir.
18th,
9 a.m.
9 a.m. in person. Thank you.
Yes, sir.
Oouchie Court Watch, we're on the scene. Truths unravel, and what does it mean? In the halls where stories clash, Oouchie Court Watch, quick as a flash.